So we need to talk about some very important developments in some of the critical assault weapon and then also magazine ban challenges that are currently seeking Supreme Court review. We've got some developments in this that we need to break down. Now, really quick before we jump into this video, I want to thank everybody that supports the channel. Just wanted to ask you guys, if you find value in this video and just the channel in general, please consider subscribing to the channel. That also helps the channel to grow, to hit the algorithm. And then also make sure you like this video. I would love for everybody to like the video, and then just drop a comment down below, even if it's just a random comment showing your support for the channel. That really does help these videos to get out to more people. And this is a video that I think everyone would find value in, so also make sure you share it around. Now, as I mentioned in the intro, in this video, we're going to be talking about some very important developments in a few cases which are challenging various state bans on so-called assault weapons and then also various magazine restrictions. So the cases that we're going to be talking about are Snope versus Brown, Ocean State Tactical, and then also Gray versus Jennings. Now, these all three are cases that we've talked about before, but some interesting things are happening now in the Supreme Court because all three of these cases are asking for the Supreme Court to intervene in those individual lawsuits. Yesterday, the plaintiffs in the Gray versus Jennings case filed a notice to the Supreme Court that they are going to waive the 14-day waiting period requirement, which is required for their case to be distributed to the Supreme Court for conference. This is being done in the hopes that this case can actually join the Snope and then also Ocean State Tactical case during any upcoming conference, which are going to happen in January. So we need to talk about why that's being done, and then also just some general implications of what happens at conferences and what we're looking forward to in January when it comes to these cases, and what will indicate whether or not the Supreme Court is going to grant review to these cases. Now, for those not aware, the Snope case is kind of the biggest case of all three because it deals directly with a state ban on so-called assault weapons. And this case prior was GVR'd by the Supreme Court after Bruen. So this is a case that the Supreme Court is already very familiar with. The Snope case was originally set to be heard by the Supreme Court at conference on December 13th, but the court preemptively rescheduled the Snope case for a future conference. Now, in the Ocean State Tactical case, the plaintiffs there are challenging the state of Rhode Island's magazine ban and then also a lower court's denial of a preliminary injunction. This case, unlike Snope, is still at an interlocutory posture, which means it's not a final merits decision. Now, the Gray versus Jennings case is a challenge to the Delaware restriction on rifles and magazines. And in this case, the district court denied also a preliminary injunction, and then that decision was appealed to the Third Circuit. Now, this case is a little bit interesting, a little bit different than the other two, because the Third Circuit in their decision actually sided with Delaware, but instead of looking at the constitutional arguments in the case, they looked at something different. They looked at the standards and the factors to get a preliminary injunction, and they found that restrictions on magazines and rifles is not a per se irreparable injury. The Third Circuit found that some constitutional harms are irreparable. They said when it comes to the First Amendment context, a lot of the constitutional harms are irreparable, but when it came to the Second Amendment, they said that the constitutional harms are not per se irreparable. And what that means is that they are treating the Second Amendment very different from the First Amendment. Currently, all three of these cases are trying to get Supreme Court review, and recently the petitioners in the Delaware case filed a notice to the Supreme Court waiving the 14-day hold, which is required for the case to be distributed for conference. And now they waived that because they want this case to be added to the two other cases that are likely going to be conference in the Supreme Court during the month of January, probably on January 10th. Now, you may be asking yourself, why are all three of these cases targeting that January 10th deadline? And that's because all these cases want conference before the end of the upcoming term, and they want the opportunity for their case to also be relisted at least once and then ultimately granted review after that. Now, you may also be asking yourself, why am I emphasizing the relisting of all three of these cases? Why would the petitioners here, why would the plaintiffs want their case to be relisted? Isn't that a bad thing? And you're not wrong for thinking that maybe that would be a bad thing because it sounds like a bad thing, but usually relisting is actually a good signal. And that's because there are a ton of Supreme Court analytics and data and tracking on prior cases that show that cases have actually a higher odd of being granted review by the Supreme Court if they're relisted at least once. In fact, there's actually an article on the SCOTUS blog that I highly recommend. It's written by John Elwood, and in that it analyzes all the Supreme Court cases in prior years that were relisted and then ultimately granted review. According to the data for the court's 2016 to 2020 terms, between 31% and 43% of all petitions that were relisted at least once were eventually granted review. And when it came to all the cases that were granted cert from 2016 to 2020, about 66% to 75% of all of those cases were relisted at least once. So the fundamental truth has become that the justices most likely will grant review to a case if they have relisted that case at least once. Now, also according to all the data, that 2 relists are not better than just 1. That means that the data shows that if a case is relisted 1 time, it has a high odds of being granted review, but the second it gets a additional relist, a second relist, a third relist, the data shows that the odds of it getting granted review go down, and it goes down significantly. The odds after that, if you're seeing multiple relists, is that you are going to get a denial of that case and then likely a dissent from one of the judges. For example, in 2022, 42% of all cases were granted review only after 1 relist. In contrast, only 28% of cases were granted review after they were relisted 2 times or more. So again, what we want to see in all of these cases and what they are targeting is a conference and then a relist for a subsequent conference, and then ultimately a one and done grant of review in these cases. Now, also one of the things that makes all these insights even more important is the fact that the Supreme Court has a shrinking number of cases that they're actually granting review in. And because of that, the Supreme Court has become less likely to relist any cases that they don't either intend to actually grant review in, or at least comment on the denial and ultimately write a dissent in that denial. So where does all this data and where does this development leave us in these cases? All 3 of these cases are trying to get distributed to the January 10th conference. That gives these cases the opportunity to be then relisted to the next conference and then hopefully receive an order the following week, which would be a grant of review in those cases. Now, I also want to say that multiple relist does not necessarily mean that a case is going to be denied, but the data does show that the chance of granting review in these cases goes down the more times that they are relisted. Now, you may be asking yourself, why are relists important? What is the Supreme Court doing during this whole relist process? And again, the relist is a strong indicator that the Supreme Court is actually interested in the case. There are a ton of articles written on this very specific topic, and typically at the first conference, you have the justices which are actually going to vote on whether or not they want to grant review to the case. There needs to be at least 4 votes to actually grant review and grant cert to the case. But keep in mind, strategically, you want at least 5 votes in that case so that you can rule the way that you want. Keep in mind, this is also why, after Heller, we saw a huge lag in 2A cases, because maybe you had enough votes to grant review to a case, but you didn't have enough votes to have the majority to rule in the case the way that you wanted. Now, after that first conference, the cases are then relisted, and during that week, the justices and the law clerks dig deeper into the case to cure all the concerns that maybe they have and to look a little bit deeper at the lawsuit. And there's indications that really what happens is that the relisted cases are put then on the Supreme Court's discuss list. Now, that discuss list is really a behind the scenes kind of list of all the cases that the court is actively considering. And it's believed that only about 3% of all cases actually make it on that discuss list. In fact, Chief Justice Rehnquist in his book stated that shortly before each conference of the justices, the Chief Justice sends out a list of the petitions he wishes to have discussed. After the Chief's discuss list has come around, each of the associate justices may ask to have additional cases put on the list. The petitions that are not discussed at conference are denied without any recorded vote. The great majority of petitions are never even discussed at conference and are simply denied without being taken up by the justices as a group. So a vast majority of cases won't even be discussed by the Supreme Court, and that's why a conference is so important, because it means that the Supreme Court is actually considering and discussing that case. And then even more so, a relist means that it is actively also being discussed and considered by the court. So these cases are now entering very critical stages. We need to keep our eyes out on the docket and the entries for the Snope, the Ocean State tactical case, and the Gray versus Jennings case. We have to see when they're going to be distributed for conference. We're hoping that that is actually going to be January 10th, like the parties are asking for. The following weeks, we want to see that these cases have actually been relisted for conference. And then we hope and pray to see an order list, that following week, that one or more of these cases have been granted review. So some very important things are developing in the upcoming weeks. That's what's currently happening in the critical assault weapon and magazine ban cases that are seeking Supreme Court review. And as we get more information, I will let you guys know. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.